A number of factors determine whether an officer will issue a citation or make an arrest. These include the attitude of the store owner, the amount of items taken, the type of items taken, baby food or alcohol, age, whether the person has ID or not, the person's history, etc. Exception: Gambling NMSA 1978, Section 3019-12. Duties of enforcement officers. This article refers to illegal gambling where a judge has issued a warrant. The peace officer shall arrest without a warrant the parties therein or making their escape and who would be subject to arrest with a warrant. The officer doesn't have to witness the gambling, all that is needed is probable cause. Gambling became legal in New Mexico in 1997. Since then, this exception is seldom used. Exception: Trespassers in restricted areas NMSA 1978, Section 3021-3. Detention or arrest of trespassers upon restricted areas. This article refers to trespass in restricted areas but is seldom used. Exception: Domestic violence. Before the mid-1990s, an officer would arrive at a misdemeanor domestic violence but couldn't make an arrest. This exception permits an officer to arrest for domestic violence, assault and battery even though it did not occur in his or her presence. We will be providing more information on domestic violence later on in this class. Exception: Traffic offenses. Misdemeanor traffic offenses must generally occur in the presence of a police officer to justify an arrest. There are a few exceptions. NMSA 1978, Section 66-8-125. Arrest without warrant. Police may arrest without warrant any person, 1, present at the scene of a motor vehicle accident. To arrest without a warrant, the arresting officer must have reasonable grounds, based on personal investigation which may include information from eyewitnesses, to believe the person arrested has committed a crime. Facts: Las Cruces police officers received a report a vehicle had crashed into a house. Both driver and passengers were gone. One passenger, found nearby, identified defendant as the driver. Defendant was found at his home, also nearby, unconscious on the floor. He had visible injuries consistent with the deployment of an airbag. He was arrested for DWI and leaving the scene. Defendant argued the arrest violated the misdemeanor arrest rule because the offense did not occur in the presence of an officer. At issue was whether Section 66-8-125 permits officers to arrest an individual without a warrant who has fled the scene of an accident before officers arrive, when the officers did not encounter the individual at the scene of the accident. State v. Sanchez, 2009. Answer: Supreme Court held that an officer can arrest individuals who either are or were present at the scene of a motor vehicle accident, when the arresting officer has reasonable grounds, through personal investigation, to believe the individual has committed a crime. The arrest, however, must take place with reasonable promptness from the time of the accident. Arrest with a warrant when practicable. There are advantages to getting an arrest warrant. Probable cause has been decided by a judge. Can be executed anywhere in the state. Do we need a warrant in the following situation? Facts: Officers had been investigating subject for approximately 1 year and had probable cause to arrest him. Prior to arresting him, the officers learned from a reliable confidential informant that the subject would be driving in Roswell, New Mexico the following day to do a drug transaction. The next day the officers saw the subject approach the intersection described by the confidential informant. The officers arrested the subject without a warrant. The officers searched the subject and his car. 7 packages of heroin were found. Campos v. State, 1994. Was this a reasonable arrest? No. Is the evidence admissible? No. Answer: Officers had a year to get an arrest warrant. Supreme Court felt defendant's arrest was unreasonable because there were no exigent circumstances. An arrest without a warrant requires probable cause and exigent circumstances. If an officer observes a felony, exigency is presumed. Officers had sufficient time to get a warrant. There were no emergency or exigent circumstances. Therefore, evidence seized at time of arrest was inadmissible. Lesson learned: if we have time to get a warrant, we need to get a warrant. Place of arrest: it makes a difference whether it's suspect's own house or that of another. Entry into defendant's home to make an arrest. Supreme Court held that officers, absent consent or exigent circumstances, need an arrest warrant to enter a suspect's residence to arrest a suspect. If you see or have good reason to believe a person is in her/his own house, you can enter the house to make an arrest if you have an arrest warrant. Payton v. New York, 1980. Entry into third party's home to make an arrest. Facts: DEA agents received a tip that a federal fugitive was in Stigald's house, although the fugitive did not live with Stigald. The agents went to Stigald's house and searched for the fugitive, whom they did not locate. However, they did observe cocaine and Stigald was charged. The United States Supreme Court held that, unless officers have the consent of the resident or exigent circumstances are present, they must obtain a search warrant to enter a third party's residence to search for a wanted person. The evidence, cocaine, was suppressed. If you see a subject in another person's house, you need an arrest warrant and a search warrant to enter the house. Stigald v. United States, 1981. Entry into a shelter for battered women. A law enforcement officer needs to obtain a search warrant before attempting to serve an arrest warrant within a domestic violence safe house or shelter, absent exigent circumstances. Employees of domestic violence safe houses or shelters do not commit either 1. The crime of resisting, evading, or obstructing an officer, or 2. The crime of harboring a felon if they request a valid search warrant before allowing a law enforcement officer to enter the safe house or shelter. Arrest without a warrant, need probable cause and exigent circumstances to enter house. Consent is also an exception to the warrant requirement. Examples of exigent circumstances: hot pursuit, destruction of evidence, danger to officer or others, likelihood of escape. Information regarding arrest and domestic violence. Domestic violence is discussed in a separate class. Some questions are frequently asked: when can an officer make an arrest, when is an officer required to arrest a person, and what happens if both parties in a domestic violence battery appear to be equally guilty? When is it discretionary, up to the officer, to decide whether or not to make an arrest? NMSA 1978, Section 31-1-7. Arrest without warrant, liability. A peace officer may arrest a person and take that person into custody without a warrant when the officer is at the scene of a domestic disturbance and has probable cause to believe that the person has committed an assault or a battery upon a household member. When is it mandatory, required, for an officer to make an arrest? Chapter 40 of the New Mexico State Statutes is about domestic affairs. Article 13 relates to family violence protection. In these cases, someone has already gone to see a judge and has obtained an order of protection. One statute discusses a peace officer's authority to arrest. NMSA 1978, Section 40-13-6. A peace officer shall arrest without a warrant and take into custody a person whom the peace officer has probable cause to believe has violated an order pursuant to this section. What should an officer do if it looks like both offenders hit each other? The state of New Mexico discourages dual arrests of persons involved in incidents of domestic abuse. An officer, making an arrest for domestic abuse, shall seek to identify and consider whether one of the parties acted in self-defense. NMSA 1978, Section 40-13.1.1. Alternatives to protective custody. We have repeatedly stressed that we need probable cause to arrest someone. However, there are situations where we can take someone into custody without probable cause. Alternative to probable cause, protective custody. NMSA 1978, Section February 8, 43. An intoxicated or incapacitated person may be committed to a treatment facility for protective custody if the authorized person has probable cause to believe that the person to be committed is disorderly in a public place, is unable to care for the person's own safety, has threatened, attempted, or inflicted physical harm on himself or herself or another, has threatened, attempted or inflicted damage to the property of another, is likely to inflict serious physical harm on himself or herself, or is incapacitated by alcohol or drugs. Alternative to probable cause, mental disorders. NMSA 1978, Section January 10, 43. Facts: a police officer was given a doctor's note which authorized the officer to transport a patient to a mental health facility. The officer was concerned because of the absence of a legally valid order. What should the officer do? Answer: an officer can, in specific situations, detain and transport a person for emergency mental evaluation and care in the absence of a court order. These exceptions are: person is otherwise subject to lawful arrest. Reasonable grounds to believe the person has just attempted suicide. If an officer has reasonable grounds to believe the serious harm to himself or herself and that immediate detention is necessary to prevent such harm. If a licensed physician or certified psychologist has certified a similar conclusion, such certification shall constitute authority to transport the person. Drug overdose and arrests. New Mexico has a high drug abuse rate. The legislature has tried to be innovative in coming up with new ways to reduce drug abuse. A person who, in good faith, seeks medical assistance for someone experiencing a drug-related overdose shall not be charged or prosecuted for possession if the evidence was gained as a result of the seeking of medical attention. A person who experiences a drug-related overdose and is in need to medical assistance shall not be charged or prosecuted for possession if the evidence was gained as a result of the overdose and the need for medical assistance. NMSA 1978, Section 3031-27.1. Lesson learned. The idea behind this legislation is that a person who is going through an overdose or watching another go through an overdose will ask for help. Consular notification. What to do when a foreign national is arrested. According to international treaty, if a person of one country is arrested in another country, the second country has an obligation to notify a consular of the first country. A consular, similar to an ambassador, looks out for the interests of their country's citizens. Law enforcement has an important role in this. Once an arresting officer determines a person is a foreign national, the officer needs to advise that person of their right to consular notification. The officer should also inform the detention facility that the person is a foreign national and of their right to consular notification. Once done, the detention facility is responsible for consular notification. The officer's actions should be noted on the arrest/booking form and police report. What to do with children when an adult is arrested? Don't forget the obvious. When arresting an adult, an officer should assist children, present or elsewhere, who may be at risk because of the arrest. This may include arranging temporary care for the children. Conclusion: we have discussed many issues in Part I. In Part 2 of Laws of Arrest we'll discuss 1. What is needed to do a vehicle stop? 2. Issues involved in a vehicle stop.